Good day, everyone. I'm Alan Galloway, Area Farm Management Specialist with University of Tennessee Extension. Today I'm going to be sharing a series of slides and information related to just the basics of estate planning. This is April of 2020, and a lot of people have, I guess you might say, had a little extra time on their hands to think about and consider exactly where their estate plan is and whether or not they even have one. So I wanted to share some basic information for everyone. A little bit will be pointed directly more to our agricultural clientele, but I think this information would be of interest to anyone that's wanting a little bit more information about the basics of estate planning in general. So with that, we'll move on into our information and hopefully get along with some topics that'll be of interest to you today. First off, here's what we're going to try to cover. I want to give you a little bit of an update on what we refer to as farmland legacy and a link to that information. We'll talk a little bit about, well, what is estate planning? What is entailed in the process of doing estate planning? What are the items that you need? What are the parts of an estate plan? Exactly what are the planning documents that you might need to have included as part of your estate plan? And then we'll discuss a variety of other items and tools, you might say, that assist with estate planning and the other needs that you might have to conclude or make sure that your estate plan is carried out as carefully as you want it to be, as accurately as you want it to be. With that said, let's talk about a little bit about the Farmland Legacy Program. It began a little bit over 10 years ago in Tennessee. It was designed to assist with helping Tennessee farms stay in the family. The intent was to provide information to our farm families across the state to assist them in developing an estate plan, also with developing plans for farm transition or farm succession. Those topics particularly might be covered in another series. Currently, the materials that we have on hand for that program are available at farmlandlegacy.utk.edu, as is showing on the screen. There is a major large document there that we are in the process of updating, but the current document, the 200-page manual, does have a lot of valuable information within it. We will be updating it later this year, so it'll be of more pertinent information as far as that goes. There are a lot of other small documents and bulletins that's in that website as well that has a lot of specific details related to estate planning and other topics related to that. All right, well, let's think a little bit about some questions just to start off the bat. One, do you need an estate plan? And we'll try to talk about that a little bit today. Really, what's included and do you need one and why is one needed? And then if you have one, do you have the documents that are needed to transfer the assets that you own to the next generation and to protect you while you're still here? Those could be two different types or multiple types of documents that you might need to do both. And then another question that comes up quite often, especially related to businesses and agriculture farming, is have you identified a successor? Who will take over that farm operation should something happen to you now or happen to you years from now? Many businesses have not identified a successor or made plans for someone to take over the operation. And that may not be part of your estate plan, but it could be a critical part of it if you're going to make sure that that farm has an opportunity to remain a farm in the years to come. So let's get into the estate part of this and talk about some good news on the very beginning. I like to start with good news, and the good news is that unless your estate is worth more than $11,580,000 in 2020, there is no estate tax due. In other words, you nor your heirs will have to pay any estate tax unless your estate is worth over $11.5 million. And with proper planning, that means a husband and wife, a couple, could have over $23 million of estate, and that could be passed to the next generation, and with proper planning, of course, and there would be no taxes due. And so for most of us, the great majority of us, dealing with estate tax is not a critical matter. However, estate tax or not having to estate tax does not eliminate the need to do some estate planning. There are still some big money saving factors and other reasons that one needs to do estate planning for yourself as well as for your heirs. My first major point is that somewhere in this process, you are most likely going to need a qualified estate attorney and quite likely a good CPA and accountant to help you deal with some of the financial side of the estate planning process. I emphasize here an estate planning attorney because there are many attorneys out there and they have a lot of specialties. Many of them do. Some are very general attorneys and do a lot of work in a variety of legal matters. Others spend many hours of additional training learning more about estate planning, and that's a fairly small number of all the attorneys that are out there. But it might be advantageous to you to seek out an attorney that does specialize in estate planning to ensure that if there is any complications or potential complications with your estate, that that attorney has the ability to ask you the right questions to know that you will get what you need as far as your estate planning documents and tools. And I just like to emphasize that, yes, it's going to cost some money. Attorneys don't do work for free. And even in today's times, they're having to handle some unique situations under our current pandemic issue. But most of them have worked out ways that they can still help you create the documents that you need and either have them worked out, having them signed electronically if they're not able to meet face to face, things like that. But you're going to have to spend some dollars for their services. And quite simply, those dollars that you spend now could save your family many dollars later on if you did not have an estate plan of any type. Well, what is estate planning? Really, what's included? Is it a will? Is it more than a will? Well, it truly is more than a will. A will, I like to think, is a good beginning of what an estate plan is, but it may include other documents and should include other documents to make sure that your wishes are carried out as accurately as possible. The purpose of an estate plan is simply to make sure that those assets that you own, that you worked your life to save up and to build and to have, that you'd like to pass on to the next generation or the one after, to make sure that those assets, that's the purpose, to make sure those assets are transferred to those heirs as smoothly and as simply as possible and with as little expense as possible. Basically, doing a good job with estate planning reduces stress. It reduces stress on you because you know you've done your part to look out for your family. And it reduces the stress on your family because they know that you've taken care of them. You've put the documents in place that should make it simpler for them and less stressful for them once you're gone. And it should reduce expenses as well, because if you've done a good job with the planning, it should make it simpler to transfer those assets to them when that time comes. Well, what may be included? Now, here's the basic list, and we'll cover these in a little bit more detail today. Number one, what is a will? We're going to talk a little bit about a will. We're going to talk about a power of attorney, what's typically referred to as a durable power of attorney. And we'll also talk about a power of attorney possibly for, or it's called a durable power of attorney for finances, you might say. We'll talk about an advanced care plan. Now, many times that's also referred to as medical directives, or a lot of attorneys still call it a living will. Those are all the same basic thing. We'll talk about a health care agent. That used to be called a power of attorney for health care and still can be. We'll talk a little bit about trusts and the different types of trusts and what may be useful and as far as a potential use of a trust. And then there's a variety of other tools and ideas related to estate planning that I just want to highlight to make sure you've at least thought of before we leave the topic today. All right, let's talk a little bit about that will. Number one, yes, you need one. Every one of us should have a will. It doesn't matter if you're 20 and just gotten married or single for that matter. If you've got any assets and something happens to you, a will simplify the transfer of those assets to whoever you'd like them to go to. And if you're like a lot of us that are older, you need to be thinking about what you've got out there, the farm, the land, the house, the cars, the trucks, whatever it may be. How simply can you make sure that those are transferred the way you'd like them to go? And that's why you need a will, among other things. If you die without a will, the legal term for that is called dying intestate. But you might say, well, that's not terrible because Tennessee, they've got a will for you. Tennessee has the laws called the Code Annotated that specify exactly what percentage is given to each heir based on that law if you do not have a will, and it specifies what percentage would go to a spouse and to children in that case. But, you know, that Tennessee law may not be the way you'd like for things to transfer. You'd probably like to have a say of exactly who gets what. And so if you want to provide the directions and make sure the assets are transferred like you want, then you need to have a will. Let's talk a little bit about that power of attorney. Power of attorney are obviously usually referred to as a durable power of attorney for finances. Why the term durable? Well, if it's just a power of attorney, it isn't effective if you become disabled. It's only good while you're still doing okay. But a durable power of attorney, which is what typically lawyers write for individuals, stays in effect should you become disabled, which is usually when you need a power of attorney. The purpose of the power of attorney is to give another individual the ability to transact business or financial affairs for you if you're unable to do so, whether you're laid up in a hospital, heaven forbid in a coma or something like that. Then if you're not able to take care of your affairs, this person who you've given this power of attorney to would have the authority to go transact business for you. They could put money in a bank, take out of the bank. They could sell land if needed to generate cash for your care, whatever it might be. They would have the same authority as you beginning the day you give them this power of attorney. Now, obviously, you're going to select someone that you trust because, you know, that's obviously what you do. You can name more than one person. Quite often, it's recommended to name a backup person. So if you name one individual in that document, that power of attorney that says, you know, let's say that person A is going to have my power of attorney, but person B is a backup should something happen to person A. And so you can do that. Now, sometimes they don't always recommend naming two people to serve at the same time because they might not agree on a financial issue that needs to take place. And so if you have a trusted individual that you could name as power of attorney, then that's usually the recommendation. Other unique things about a power of attorney is that power of attorney is only valid while you're alive. Should you pass away, then that power of attorney is no longer effective. And at that point, obviously, your will takes over. And in that will, you will have named an executor or executrix, if it's a female, of who oversees the process called probate of your estate. And so that will takes over when you pass away. The power of attorney is effective to handle financial matters or to handle financial matters for you if you're unable to while you're still here. Of course, should something happen to that power of attorney, that individual you've appointed to be your power of attorney, you can revoke it. You know, if maybe they have a medical issue or some other calamity that would not allow them to serve any longer, you can revoke their power of attorney and appoint someone else. So it's not a matter of once you've given it, you can't take it away. You can if that's necessary. But this could be critical mainly if you're still here but unable to take care of yourself. And that's where estate planning becomes much more than just that will that takes care of things when you're gone. The power of attorney helps take care of things while you're still here. Well, what about advanced care plan? As I said earlier, that's also the same thing as medical directives, advanced directives, or a living will. Those are all the same documentation, basically. What's their purpose in this estate plan? Basically, most of us, I think, fairly logically, that if we're in such a medical condition that we're not going to get any better, whether we're in a coma because of a car wreck, whether we've got a terminal uh, medical condition that we're not going to be around for long, and we know that, we might want to have, and I think anybody should have at any time, whether they're healthy or sick, should have an advanced care plan of some sort that specifies what level of medical care we would like if we're unable to say. So if we're in a coma or we're, you know, incapacitated in some way and I can't tell or you can't tell the doctor what you want them to do for you should you get worse. Should your heart stop, would you want to be resuscitated? If you could no longer eat, would you want to be on a feeding tube? Those sort of things can be addressed in your living will or your advanced care plan. and to specify that so the doctors and your family would know exactly what level of care you would want if you were in that sort of a condition that you weren't going to get any better. Would you want them to just let you go or resuscitate you and all that sort of thing? So that's one of the reasons that this document could be very important. And I assure you, practically anytime you go to a hospital, to a doctor's office, to especially an emergency room, they're going to ask you, do you have a living will or an advanced care plan? So basically, by creating this documentation, you're putting your say on what you want done to you or for you should you not be able to say. So it clarifies for the doctor and for the family what level of care you want. Also in that documentation, you can specify whether or not you'd want to do organ donation. You can do that on your driver's license as well, but this is another place you can point it. Now, my second point I don't want to skip by too far here is the healthcare agent appointment. This used to be called, or can still be called, a power of attorney for healthcare. This is kind of like that durable power of attorney for finances, but this just relates to healthcare and healthcare decisions. And I like to think here is where you might want to appoint somebody, and it might not be a family member, because you need somebody that is going to back you up on what you put down in your advanced care plan of what level of care you would want. So if you said, you knew that your whatever medical condition was terminal, and you decide that if your heart stops, just don't try to restart me, let me go. And you've explained that in your advanced care plan, and you would also explain that to the person you've appointed as your healthcare agent. And that healthcare agent would be the person that would back you up, because you're not able to say, and they would tell the doctors and the family, the rest of the family, that, hey, this is what they told me, that if they're in this shape and, it's their time, let them go. Let's not be putting their body through additional medical procedures that they don't want or wouldn't want if they were able to say. So obviously that healthcare agent needs to be somebody that's got some backbone, that's willing to stand up to the doctors and to the family who might be wanting to give, extra care in hopes that you would get better, or even if that wasn't what you would wish. So it can be a very important document should you ever be in that condition, and at least gives you the possibility of saying, rather than family having to make those decisions for you. And another point I like to make here is that when someone is critically ill, and typically the doctors are going to ask a family member to sign up and decide whether or not that there should be other medical procedures provided for that person. In other words, somebody might have to sign what's called a DNR, a do not resuscitate order, and that is not something you want to put a family member in the particular position of having to sign if you can avoid that at all possible. So I like to say this is where you can take a lot of stress off of a family member, maybe a son or daughter, from having to sign a document that says do not resuscitate my parent, because because they're in a critical situation, they're not going to get any better. But that's a tough form to put them in the situation of signing, and you could take that load away from them by having it specified in your advanced care plan what kind of level of care you would want. All right, moving on along, let's talk a little bit about trust, because it's a topic that gets mentioned a lot and it can be very confusing. And I will say up front today that it is impossible to cover all the details about trust in our short time that I'm going to have here on that topic, but there is where a good estate attorney comes into play. And a state attorney that can cover all types of different topics of estate planning, that has good basic training, can help you decide whether or not a trust is something that would be better in your particular situation than to go along with your will or as part of the estate plan, or whether it might replace the will in some cases. We'll try to touch on some of those a little bit today. A lot of times trusts are created by younger individuals as part of their estate plan by their will. Their will may say, and as part of the will, the will is going to create a trust to set aside funds to take care of the raising of their children if they're not here to do so. And so that's my apologies for the ringing in the background. But anyway, the trust could take care of children. It could be used to protect certain assets. For example, if you had a business that had to have an ongoing cash flow to stay operating, and it's a business that if you weren't around, you would want your family to sell it to somebody else. For that business to have a high value, then that business needs to continue operating in many cases. My favorite example there is a dairy farm. Somebody's got to keep the cows milked, the cows fed, keep it operating until the family can decide, if you're no longer here, whether or not to keep the dairy going or to sell it. But if it's not operating, then that couldn't happen. So sometimes you have to have a cash flow set aside, and a trust is a way that can be done to keep the farm operating if nobody else is able to do so. There's a term that I use here is called testamentary trust. That's a trust that's created by the will. And there again would be a prime example of the will saying that if we pass away and we still have minor children, then a trust would be created to set aside funds for the raising of those children, or to set aside funds for their college later on, that sort of a thing. As I mentioned earlier, there's multiple types of trust that are lifetime trusts that only exist during your lifetime to protect assets. After you're gone, then the will might take over and take care of those assets. So other terms you hear used with trust quite often are revocable trusts or irrevocable trusts, and that's just what they are. A revocable trust can be changed if need be later on. It can be revoked and altered or whatever. An irrevocable trust means that assets, no matter whether it's cash or land or other assets that are placed into that trust, and it's an irrevocable trust, then those assets cannot come out of that trust. They have to stay that way. That's not as used as often anymore as it used to be, but it still could provide usefulness in some rare conditions. The other trust that I want to spend a little bit of time on is called a living trust. And you see a lot of situations where people are recommended to get a living trust instead of a will. And I don't particularly like that recommendation, and I'll tell you why. Because a living trust, to work properly, has to contain all of the assets that you own that are titleable or have a deed to them or anything like that. So all the land you own, all the cars and trucks you own, anything that's got a title or deed to it has to be in that trust. It has to be properly titled or deeded into that trust. The living trust has to own basically all those assets. Then the documentation of the living trust would say what happens to those assets when you pass away. And in that sense, it acts the same as the will without having to go through the probate process. And that is usually where some individuals over promote, I'll say it that way, a living trust. They say, oh, your estate won't have to be probated if you have a living trust. And that could be true if the living trust owns all those assets. But if you have one vehicle or one piece of land that you are owner of or part owner of that is not in that living trust, then you're still going to need a will. So you may or may not avoid the probate process. And in Tennessee, the probate process is not that expensive or that complicated, such that it's something that really has to be avoided. The other issue I run into here a little bit with living trusts is they have to be updated. So anytime you change or buy another vehicle, buy another property, land, anything like that, any piece of property, then you're going to have to make sure that those documentation of those items is proper so it stays in that or is in that living trust. And quite often the fees charged for creating a living trust is substantially more than what it costs to have a will written. And sometimes I find that there are a few folks that maybe promote a little too strongly the living trusts, and when I don't know that they're necessary. But this again is where a good attorney can help you decide, is the living trust something that you really need, or will a will take care of what you have as simply and less expensively? So there again, if you get a good recommendation from a logical attorney on that, that might be a better way to go for you, I've got no problem with that. It's just one of those things you need to research carefully and make sure that you're not getting something pushed in your direction that might not be of that great of an advantage for you in your overall estate plan. If I'm one of those frugal types, if a will take care of it for quite a few $100, if maybe not thousands of dollars less than a living trust, then I'd go for that. All right, other items to talk about in estate planning. There's a lot of them there. Number one, you need to think about the land that you own and exactly how is it deeded? Whose names are on that deed? Is your home owned by just you and your spouse? And that's fine. Typically, if it's an asset like that that's owned between you and your spouse, then it transfers to the spouse automatically. To whenever the first spouse passes, it goes to the surviving spouse, and that's usually not complicated at all. But if you owned land with other individuals, whether it's relatives or non-relatives, you need to think about exactly on what the wording of that deed is. Because typically, if let's say it's you and your brother own a piece of property, then you technically own it 50-50. And if something happens to you, then your heirs will now own half of that property, and your brother would still own the other half. Likewise, if something happened to him. Now, a deed can be worded with what's called right of survivorship, which means if two owners own it, you and your brother, example again, and one of you passes away, then now the other one owns the entire thing because they owned it by right of survivorship. Whoever survived ends up with the whole property. Sometimes it's advantageous to have it worded that way because then that property would transfer, wouldn't have to go through the probate process or the will or anything like that. It could be transferred, and with proof of the decedent's, the one that passed away's death, then the other person could get the deed changed into their name and proceed along that way. It might take a little bit more than that, but it's not complicated. But it's good to know exactly how those are worded. So you may have property you own that doesn't have your spouse's name on it. And then that's all yours currently, and then your heirs would share in that when you pass. If you have no will, that would get split up amongst the heirs. If you have a will, it would specify how it goes if it's just in your name. Other things to think about are forms of ownership. If you have a business or a farm or whatever it might be, and it may be a partnership or an LLC, the documentation of those partnership or LLC may specify what happens if one of the partners dies or passes away. So that could impact the estate plan as well. You need to double check those sort of things. If you have an IRA, an individual retirement account, or a 401k through work or somewhere, you need to make sure that you have the beneficiaries listed in the documentation of those items. So if you have it with an investment company or a brokerage company or a bank that has your IRA or your 401k, you need to make sure that you specified whether you want that when you pass to go to your spouse or to go to your children or grandchildren, whichever it may be, because those will transfer separate of the will. If you don't have any beneficiaries listed in that documentation, then it gets divided up based on whatever your will says. So if you have the beneficiaries listed here, the will cannot override it. So it goes to whoever is listed as a beneficiary. So two important points here. One is make sure you kept your beneficiaries updated, because you probably don't want to leave, your IRA to someone that you're no longer with. Quite likely you wouldn't. So you might want to leave it to your current spouse or your children or grandchildren, whatever the case may be. There was a significant law change that took place in January 2020 that I want to highlight here, and it changed the rules related to beneficiaries. If a spouse inherits an IRA or 401k, it can, as I understand the current rules, become their IRA or 401k, or they can have it listed as a beneficiary IRA. So, and then the calculations of whether or not a required minimum distribution takes place when they turn age 72 now, then it would be based on their age and not what your age was when you passed away. If you leave the IRA or 401k to your children or grandchildren, there used to be some advantages to that, but they've basically taken away some of those advantages with the law change that started the 1st of 2020. Basically, the rule now is that the non-spouse heirs, with a few exceptions to this, but just about all non-spouse heirs have up to 10 years maximum to take that money out of that IRA or 401k. Now, if it's a traditional IRA or 401k, then the money as it comes out is taxable. So if you had a substantial amount of money in that IRA and that child, let's say, inherits it or is the beneficiary of it, and they've got 10 years to take it out, even if they take it out in 10 annual chunks, it might be enough money to change their tax bracket, and could be because it's taxable income to them. And so that's a factor in this. If it's a Roth IRA or 401k and is not taxable income, then the beneficiary could choose to take it out annually or all at once, or could wait till the end of the 10 years and take it then, because they're not going to have to pay tax on a Roth version of an IRA or 401k. So there are some factors there to think about, depending on how you'd like to. It may entice you to use some of the money in your IRA or 401k rather than having as much of it left to pass down, if it's going to create a taxable situation for those that would inherit it. But you still need to make sure those beneficiaries are updated. Other tools you can use in estate planning, one is life insurance. Many times, especially with farming, one of the challenges that a person has when they have multiple children is they may have some children that want to keep the farm operating, want to live on the farm, keep it going into the future. There may be other children that have moved away from home that have no connection to the farm, that may not be interested in the farming operation, but you still probably do not want to leave them out in your estate plan. Life insurance may be a useful tool where you could leave those non-farming heirs the proceeds from a life insurance policy so that they have inherited some cash in this case, rather than inheriting the land and farm equipment and such assets as that. So that does provide an additional tool. Life insurance can also be obviously valuable as part of the means to provide monies to keep the farm operating in some cases. So there's a lot of uses there. Another thing I want to try to mention briefly is related to churches or charities or schools that you went to, places you might like to donate something to. And I know often people say, well, if I give away much, I wouldn't have any estate left to leave my heirs. But there may be other ways that you can do that through charitable remainder trusts and other ways. And if you have an interest in doing something like that, I strongly suggest you discuss it with your attorney, and or discuss it with that school, church, or charity that you might be interested in giving it to, because typically they have people that work directly with folks that are interested in giving assets or cash in some cases that could be a donation as part of their estate, and they're usually very willing to work with you on that, even for some smaller amounts in many times. All right, other items to think about, some other tools. One I want to mention briefly that get talked about, especially to our landowners that are interested in, is something called a conservation easement. I'll spend just a few minutes trying to cover that one. It's also typically called a land trust. Basically what it does is it is a change in the deed of that property and the requirements of that property that it is placed into this conservation easement, that it such protects that land, as they say, into perpetuity, which means forever, and that the future uses of that land can only be one of three things, or all of these three things possibly. That land in the future could only be used for farming, for recreation, or for wildlife. It would, in most all cases, prevent that land from ever becoming a subdivision of houses or a business park or something like that with industry all over it. It would, does provide a possibility of protecting that land to keep it like you've got it now, forever. Now, there are some significant things that does. It lowers the value of that property. Obviously, if that land can only be used for those three things, any future owner is not going to be willing to pay as much for it. So you're not going to have a developer that wants to buy it because they can't put houses all over it. You're not going to have an industry wants to buy it, or a business that wants to buy it because they can't build a business on it. It can only be used for those three things. So it does permanently lower the value of the property. Now, there are some, you might say, some catches to this thing. As I mentioned earlier, it is forever. It's into what they call into perpetuity. There are some potential income tax savings for the current owner that puts the land into the conservation easement. Basically, real quickly, how this works is the land would have to be appraised, and that appraiser would have to establish a current value of that property or a best use value of that property. So if it could become is land such that it could be a subdivision or an industrial park or have other valuable uses, they would value it at that level. And then it would also create a value of it after the easement of what it would only be worth as the farm or for a wildlife viewing area or for recreation purposes. And so the differences between those two values is the value of that easement that you're giving up, that reduction in value. And that could in turn become a potential income tax savings because the person that's putting it into the easement can offset, in some cases, up to 50% of their adjusted gross income or adjusted taxable income, let's put it that way, by the value of this reduction in property value. And so if that land was valued very, very highly currently and it was a major reduction in value or a lot of acreage, then that could be a substantial amount of potential tax savings, and it can be spread out over a number of years. So if you couldn't use up all of that value in 1 year, then it could be multiple years. For farmers, in full-time farmers, in some cases, they can qualify for up to 100% of their adjusted taxable income could be reduced by having put land into a conservation easement. Now, it's not without expenses that you're going to do this, because obviously somebody's got to do that appraisal. Probably there's going to have to be a survey of the property. There's going to have to be new documentation, deeds, and other paperwork drawn up. So this isn't something that can be done extremely cheaply to create a conservation easement, but for the person that might end up with substantial tax savings, and for the person that or the person that wants to protect that piece of property forever, it may be a useful tool. And it's one of those things that I suggest you talk with an attorney or someone like the Tennessee Land Trust or the Foothills Conservancy that deals with people regularly about putting land into conservation easements. Now, there's other groups in Tennessee that do it as well. Those are just the two of the bigger ones that may be in the state, but there are others that you might want to consider talking to as well, or talk with your local extension agent that could provide you some background information as well. Other estate planning tools I want to mention briefly that one should consider. One is disability insurance, especially if you're in the business of farming. Farming is still quite dangerous, and if you became disabled, what would happen to your land and to your house if you were no longer able to work? And if you don't have disability insurance provided from where you work, should you consider buying it outside? It's not typically extremely expensive, but you have to think about it. If you weren't able to work and you were laid up because of physical impairments, would you still have enough money to keep the house, to keep the farm, to keep it going? And so that may be worth considering a purchase of something like that. Long-term care insurance, that type of insurance that would cover you if you're in a nursing home or an assisted living facility or something like that, or might even pay for your care at home if you're unable to take care of yourself. That type of insurance is quite expensive depending upon how old you are, and you have to factor in the cost of it versus what it could mean to you benefit-wise if you needed it. And that's just one of those things you've got to look at individually and decide if it's worth it to you to purchase that type of insurance to protect your other assets if you're ever in a nursing home or something, a situation like that. A lot of questions in that area. Other things you could do: burial prepayment or burial insurance obviously is something you could help your family with, because if you've purchased a policy or done a prepayment program with a funeral home or insurance that provides funeral type coverage or burial coverage, then you have basically taken one load off your family. That's one expense they won't have to worry with because you've got that expense covered. Typically, those type policies are sold at a certain value today that covers the type of service and casket and all that sort of thing that you would want. And most of them have an inflationary clause in them that it should that cost go up, it will cover it in the future, no matter whether it's 5 years, 10 years, or 50 years from now that you actually pass away and need that coverage. A couple things you want to make sure of on those policies is, one, that it is transferable, that it's not just good at the one funeral home you buy it at, if you bought it from a funeral home, because should that funeral home go out of business or something like that, you want to make sure that that policy could be used at another funeral home or whoever purchases that particular home in the future. And you also want to make sure that it includes pretty much everything, including what's called opening and closing, which is the digging of the grave and the filling back in. Sometimes the policies don't cover that, and that can be, in some cases, quite a few dollars just for that service alone. So make sure it covers pretty much everything. Other things you can do is the gravesite, the memorial garden. If you've got the plot purchased and the stone already up, then all the family, your family will have to worry with someday when you're gone is putting that last date on there. And that's one less thing for them to have to worry with, one less expense for them to have to worry with. And the other thing that I sometimes forget to emphasize, but I wanted to make sure I had it included here today, was a letter of last instructions. Sometimes I've seen a document some lawyers have that they provide to their clients called What My Family Needs to Know. Basically just a document, a booklet, or a piece of paper or something that jots down those things you would like to have happen when you're gone. What type of flowers you would like at the service, what type of songs you would prefer be sung, because those are the things your family would want to provide if they just knew. And of course, you won't be here for them to ask anymore what you'd prefer. So if you've got it written down for them, those sort of things. Other instructions could include wherever all the paperwork is. Where is your deed? Where is your will? Where is all of those documentation that you've put together? Where are they located? Who knows where they are? And if you've got all that written down on a piece of paper and somebody, or a document of some sort, and somebody in the family knows where that, at least that piece of paper is, then that'll help them find everything else and make sure that your wishes are carried out, which is what they would want to do anyway. All right. Other things that I want to definitely emphasize here is communication, because that is probably the toughest part of all estate planning, is trying to explain to your family what you would prefer happen when you're gone. It's not a very fun topic to bring up at any time, but it's something that they need to understand. Many times it just helps make sure that everybody's on the same page, so that you've expressed to your spouse and your children what you would like to have done when you're gone. Sometimes you may want to get their input before you do all the documentation. They may have some suggestions of how to divvy up the assets that you might not have thought of, that might make it easier for everybody, or maybe it's the way that they would prefer that you didn't know they would prefer it be broken up. Maybe one of them would like the house over large tracts of land, or vice versa. And so knowing that in advance helps you in putting the documentation together. So it may be beneficial to have a little chat with the family ahead of time before you start the entire process, or before you update your estate plan, just to make sure that you're all on the same page, have the same kind of thoughts. And it does help to include all family members, including daughter-in-laws and son-in-laws, because that way they understand your wishes as well. And when everybody understands up front, the likelihood of it happening as you would prefer when you're gone is a lot more likely. So as I like to say, when everybody's on board, the stress drops because you've done your part. They know you've taken care of them, and it should go a lot smoother now and in the future as far as that goes. So I like to say my quick major points as I wrap up today is, one, you're probably going to need a good qualified estate attorney to help you do the documentation. Again, there are software packages out there that help people write their own will, but you and I aren't lawyers, and there might be something that those general type software programs might not know that's specific to our state laws, or might not know the right questions to ask that's specific to your particular situation, that a good attorney could ask and help make sure that you're getting the documentation that you need. So you're probably going to need that good estate attorney just to make sure. And I know it's going to cost a few bucks, but it'll be money well spent in most all cases. So you're going to need that will. You're going to need that power of attorney. You should draw up those advance directives or that living will, and maybe appoint that health care agent to make sure that's taken care of as well. And once you've got those documentation in place, you can rest a little easier as well as your family can. Then you got to communicate all that to your family and make sure that they understand what your wishes are and how to get it all carried out. So basically finish the job. Most of us have worked a good bit of our life trying to put a little money away, hopefully paid for a few assets along the way, have a house or maybe a little land too. So make sure you take care of your family and just do it. That's the key thing. That'll wrap up our session for today. I hope I've given you a few ideas of the basics of estate planning. I will offer that if you've got questions, I'm not an attorney, but I'm glad to help point folks in the best direction I can related to estate planning, especially for our farm families, but for anyone for that matter. And that's why my email and work phone number listed here. Of course, unfortunately, currently I'm not in the office due to the current pandemic, but we hope to be back there soon. We'll be back there, but I'm still checking email daily and can answer those questions as need be. Ladies and gentlemen, that concludes our session for the day. Thank you very much for your attention.